Hello everyone, welcome back to another episode of our channel Law Point, and this is me Preeti here. In the last video, we talked about bail, which is when you apply for release from jail when you get arrested. In today's video, we are going to talk about anticipatory bail, which is when you apply for bail when there is anticipation of arrest. To shed more light on this topic, we have Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph.
In our previous session, we saw what a regular bail is and how to get one in bailable and non-bailable offences, with the difference being getting a bail in bailable offence is a matter of right, whereas getting a bail in non-bailable offence is solely at the discretion of the court. However, regular bail in bailable as well as in non-bailable offences is granted only after arrest by police. But what if you anticipate arrest and want to take measures to avoid it? Is it possible to avoid the shame of getting arrested? The answer is yes, and the provision is called anticipatory bail. So, why was the need felt to introduce anticipatory bail? Because personal liberty is an important right granted to all citizens under Article 21 of the Indian Constitution, whereby no person should be confined unless and until held guilty after proper trial by a court of law. With this objective to protect the interest of public, the Law Commission of India, in its 41st report in the year 1969, pointed out the necessity of introducing a provision in the Code of Criminal Procedure enabling the High Court as well as the Sessions Court to grant anticipatory bail. Hence, when the Code of Criminal Procedure was amended in the year 1973, a provision for anticipatory bail was inserted under Section 438. This provision allows a person to seek bail in advance if he feels that he may be arrested for a non-bailable offence. If it is bailable offence, as discussed earlier, getting a regular bail is your right, but as such, there is no scope for anticipatory bail. Power to grant anticipatory bail is vested with the Sessions Court at the district level as well as with the High Courts. If anticipatory bail application is rejected by the Sessions Court at the district level, then one can approach the High Court with fresh application of anticipatory bail. If High Court rejects this anticipatory bail application, then you can move further anticipatory bail application before the Honorable Supreme Court of India. Since anticipatory bail is issued prior to the arrest of a person, it is also called pre-arrest bail. When anticipatory bail application is filed before the court issues notice to the public prosecutor, and the public prosecutor thereafter consults with the concerned police officer and report to the court the status of the criminal case as against the applicant, and report to the court whether there exists a criminal case as against the applicant. If yes, then the status of that criminal case. After hearing the public prosecutor as well as the applicant, the court decides whether to grant anticipatory bail or not. If the court finds any of the following grounds in the application, then the court is likely to grant anticipatory bail to the applicant. Some of the grounds are: first of all, the accusation against the applicant have been made with a dishonest motive or intention to cause injury or humiliation to him. Secondly, there is a chance that the applicant may be arrested on a criminal case with baseless grounds. Thirdly, allegations are vague in nature. Fourthly, the name of the applicant is not reflected in the first information report. Fifthly, the court is convinced that the applicant hails from a respectable family, have deep roots in the society, and is neither likely to abscond nor hamper the investigation. Sixthly, the applicant is a common man, whereas the complainant is an influential person. In all these cases, the courts are likely to grant anticipatory bail. On the contrary, anticipatory bail can also be refused. Some of the reasons being applicant has absconded in the past, applicant is not cooperating with investigation, the applicant is capable of influencing the investigation, or the applicant have undergone imprisonment on conviction of any cognizable offence, etc. In such case, the lawyer for the applicant can request the court for 7 days pre-arrest notice if the police formulates an intention to arrest the applicant. In such case, on such request, the court can pass an order notice bail directing the police to intimate the applicant 7 days before its intention to arrest. While granting anticipatory bail, the court can impose conditions in the light of facts of a particular case, including a condition that the applicant shall make himself available for interrogation by the police as and when required, or a condition that the applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the police or to the court, or a condition that the applicant shall not leave India without the previous permission of the court. If any of the conditions imposed while granting anticipatory bail is violated, such as abuse of the liberty by hampering with investigation or tampering with evidence or influencing witness, or any new or supervening circumstances arising after the release on anticipatory bail, then the court can cancel the anticipatory bail granted.
Thank you so much for watching our video. Stay tuned for the next.